Hey guys, this is John Watts, and I want to go over this Brookside Properties case. This is a recent case, September 4th, 2019, from the Northern District of Alabama, so in the Birmingham area. And in this situation, the defendant removed the case from state court to federal court, and the defendant is acting pro se, so it doesn't have a lawyer. And look, it gets very complicated when you're in federal court, so I don't show this case to in any way be negative towards the person that was acting without a lawyer, but just to show how some of these concepts work about how we get into federal court. What are the things that open the doors to federal court? And can a defense do that? Does it have to be something that you're pleading? And so Judge Proctor here, and he's a judge in Northern District and has been a judge for a pretty good amount of time. And he and I litigated cases before he was a judge, and a very smart guy. And he's going to lay out some of the rules that federal judges have to follow. And so I thought that this might be interesting for you. So what happened is that we have this Vestavia Apartments, and they filed a case in the District Court of Jefferson County, Alabama. So sometimes it can be confusing. There's state district court and federal district court. Federal district court is where we have jury trials. State district court, we do not have jury trials there. You can think of it, it's a form of small claims court, or they're related. And when you're doing an eviction, or what's called an unlawful detainer action, those have to be brought in district court. And so the apartment complex said that the defendant wasn't paying his rent, and so they file eviction. So then he removes the case and files a motion to basically say, I don't have the money to pay the filing fee because let me back up. If I file a lawsuit in federal court, I have to pay the filing fee. And if a defendant removes one of my cases and puts it in federal court, they have to pay the filing fee. Whoever walks up to the federal court, knocks on the door and says, I want my case here, they've got to pay the filing fee. And so he says, hey, don't make me have to do this. Because I don't have the money, and the court ultimately doesn't reach that issue because they say the claims aren't going to survive here. So again, going back to the beginning, the legal proceedings are brought June 24th of this year in district court, and they say he didn't pay, and so they want damages here, $5,000. So he removes it. You have 30 days to remove it from when you're served. So I'm not sure when he was served, but he removed it within 30 days of the date the lawsuit was filed. So that was very good. So it goes to Magistrate Judge Stacy Cornelius, and she's one of our magistrate judges, and again, used to have cases against her, and very smart judge. And so in the notice of removal, we're going to see something here. You have to tell the court why you have the ability to go to federal court, to remove the case to federal court. And so the defendant says, well, look, this was filed in violation of the Uniform Commercial Code. Well, that's state law. And also under the Fair Debt Collection Practices Act. And then the defendant said the state court can't proceed until it's remanded or so ordered. And that's true. Once a case is taken from whichever district court judge it was in Jefferson County, and now it's in front of Judge Cornelius and then ultimately Judge Proctor, there is no case left in state court, okay? Or you could think of it as sort of frozen over there. And so Judge Cornelius says she issues what's called a show cause order, which just says, hey, here's something I'm concerned about. And whoever the show cause order is directed to, it says, you've got this deadline to explain things to me. And she says, why should I not just kick this case back to state court for lack of subject matter jurisdiction? So subject matter jurisdiction is the power of the federal court to have jurisdiction over the subject matter or the contents of the lawsuit. So not just any case can be filed in federal court. And she's saying, it doesn't look like I have jurisdiction here. And says the defendant failed to respond by the deadline, which you always want to respond by the deadline. And things can move pretty quick in federal court. And then later, the case was reassigned to Judge Proctor. So basically, the way the Northern District of Alabama does it is different than some other places. So magistrate judges are not appointed for life. Article 3 judges are. So a magistrate judge, if both sides do not consent, then the magistrate judge is not going to be the ultimate decision maker. But the Article 3 judges use the magistrate judges to handle a lot of cases. And some courts do this a little differently. They'll let a magistrate sort of run with the case, and then they file what's called a report and recommendation. Then either side can sort of object to the district court judge about that, the Article 3 judge. But typically the way we do it in Birmingham is if both sides don't agree to use the magistrate judge and let her be the final decision on it, then it gets kicked randomly to an Article 3 judge. So apparently that's what happened here. So Judge Proctor says, look, I've got to look into my own jurisdiction. Okay, I've got to make sure I have the right power to look at this. And that's true even if the case is removed. So here's the removal law. It's under 28 U.S.C. section 1441A. You can remove an action to the United States District Court that has original jurisdiction. That's either by federal question, which is 28 U.S.C. 1331, or diversity. So let me sort of explain these and we'll see what the judge says about it. Federal question is where the plaintiff, not the defendant, but the plaintiff has asserted a federal claim. So if you rely on a federal claim, then the defendant can say, hey, I can open the doors to the federal courthouse with this. Now, we're not talking about standing, which we talk about in a lot of cases. That doesn't come up here just because it's not necessary. But if you, for example, sue under the Fair Credit Reporting Act, the Fair Debt Collection Practices Act, sue under RESPA or TCPA or Truth in Lending Act, employment discrimination, then it doesn't matter where the parties are from or how much is in controversy. I mean, if you sue for $1 under a federal statute, that's enough to allow you to have the court to have jurisdiction over the case. Now, the 28 U.S.C. 1332 diversity is what we call complete diversity. So if you line up the parties, so you've got over here, it's Brookside Properties versus Johnson. And you say, let me look on both sides of the V. Is there any overlap? Anybody from the same state? On this side of the V is that side of the V. If so, there's not complete diversity. And it has to be controversy over $75,000. So let's go back to the opinion here. So federal question, case arises under federal law only if it is federal law that creates a cause of action. So then we have what's called the well-pleaded complaint rule. So that just means we look at, well, what did the plaintiff plead? And the defendant can't come along and say, well, the plaintiff could have pled that. Well, they didn't. We just look at what they pled. And so jurisdiction may not be sustained on theory the plaintiff has not advanced. Sometimes we call this the plaintiff is the master of his or her own complaint. And then they say, while we're going to afford a pro se litigants pretty good leeway here, the pleadings must still provide more than labels and conclusions. Okay. So there's no federal question jurisdiction. Well, how about diversity jurisdiction? So there's got to be complete diversity and the amount of controversy has to be over $75,000. And they say whoever brings the suit in federal court has the burden. So if the defendant is the one bringing it to federal court, removing it from state court, they have the burden of proving this, or at least showing this. And so the party must provide sufficient evidence, such as the domicile or where each party lives, the amount of damages. And so here's the analysis. Defendant has utterly failed to specifically plead why this court may exercise subject matter jurisdiction. So we've got this Brookside Properties is headquartered in Tennessee, registered in Tennessee, and the apartment complex is registered in Alabama. And so I think the defendant's looking at that going, see, different states. Because the judge says this seemingly is defendant's basis for diversity jurisdiction. But then they say, Let me get this highlighted. The very next sentence, defendant contends that plaintiff's lawsuit against him violates the UCC, and they're attempting to collect a debt in violation of the Fair Debt Collection Practices Act. So the Uniform Commercial Code is not in 15 U.S.C. 1692. That's the Fair Debt Collection Practices Act. Each state has its own version of the Uniform Commercial Code, so that's state law. And the judge says, no, there's no federal question here. So I don't have jurisdiction unless there is diversity jurisdiction. And the judge says the defendant half-heartedly states where the plaintiffs are domiciled, but he wholly fails to specify where he is domiciled. So in other words, you kind of say where the defendant lives and is a resident, but how about you? Where do you live? And so it's just not listed. And the judge says, so that precludes the court from figuring this out. There's a footnote, quite frankly, appears plaintiff as citizen of Alabama. I can tell you this apartment complex is in a suburb of Birmingham. And so given that he alleges that Mark Apartments is also a citizen of Alabama, it seems clear there's not complete diversity. All right, so then the judge says, but even if there was complete diversity, you don't come close to satisfying the amount in controversy. So the plaintiff's claims are $5,000. And then it says he, so I assume that's talking about the defendant, seeks attorney's fees and costs, but is not represented by counsel. Thus, as he cannot claim any amount for fees, it's clear the controversy is below $75. Now, maybe what the court's saying here is that the plaintiff sought attorney's fees and costs but wasn't represented by counsel in the state court, which would be very surprising to me since it was in state district court. But in any event, the judge's point is nobody's even getting close to $75,000. So the party seeking to invoke federal jurisdiction bears the burden of proving by a preponderance of the evidence that the claim on which it is basing jurisdiction meets that minimum. And the court says you didn't do that. Now, flipping back to the federal question issue, again, defendants failed to do that. And let me get this highlighted. Notwithstanding on the reliance of 1692G, again, that's the Fair Debt Collection Practices Act, it's well settled the defendant may not remove a case to federal courts unless the plaintiff's complaint establishes the case arises under federal law. And judge points out there's no federal claim in that state court lawsuit. It was just an eviction lawsuit. So state law claim seeking state law remedies, and the plaintiff cites to the Landlord-Tenant Act. And so he says, well, Judge Cornelius looked at this. Apparently this was in that show cause order, that there's no basis for federal questions. So now Judge Proctor is going to quote what Judge Cornelius said. And let me just get this highlighted. So asserts a claim for unlawful detainer or eviction. And so when the defendant cites the FDCPA, the Fair Debt Collection Practices Act, it seems that he's saying that as a defense, like, hey, you violated the FDCPA, so that's my defense to the eviction. Or maybe he's going to do a counterclaim, but that doesn't raise the federal question jurisdiction. And there's actually a recent Supreme Court case on this, a little more complicated, but a lot of times we'll see defendants will. So here's what happens. Let me back up. So a plaintiff sues you, say a mortgage company in Alabama, which is a non-judicial foreclosure state. Mortgage company forecloses, so there's no lawsuit, but then they do have to sue you to get you out of the house. So we don't call it an eviction, we call it an ejectment lawsuit. And then as the defendant, you may counterclaim against the plaintiff, and you may raise federal claims. And those defendants hate being in state court when there are federal claims, so they try to remove those. And our response is, hey, it's all based on the plaintiff's complaint, not the defendant. So what the defendant does doesn't create the jurisdiction in federal court. And so that's what Judge Cornelius and Judge Proctor are saying here. And so they're saying that we lack federal jurisdiction or federal subject matter jurisdiction, and so it's going to be remanded. So what does that mean? Remanded just means it goes back to state court. So if sort of imagine it this way, and everything's electronic, but imagine there was a paper file in state court. Well, when that is removed to federal court, it's kind of like you go grab that paper file and walk it over to the federal courthouse. And that's where it is, because you're in federal court now. But what happens if the federal judge says, I'm remanding it back to state court? Well, then you literally walk that file back over to state court. Now, again, it's not done that way. It's all just electronically. But there's one case. It starts off in state court, then went to federal court, now it's kicked back to state court. And so that's how that works. And again, I wanted to show you this, fully recognizing this can get very complicated for somebody who doesn't have a lawyer. But just to show, how does it work with removal? How does it work with a remand? How does it work with subject matter jurisdiction, with complete diversity? So nobody's from the same state on opposite sides of the V. Now, let me give you an example of what I mean by that. Let's say Bob and Cindy sue a trucking company. They're both from Alabama. The trucking company's from Georgia. Complete diversity exists. But what if there's one plaintiff from Alabama, one plaintiff from Georgia, and the defendant's from Georgia? Well, now, see, we've got the same state on both sides of the V. There's no complete diversity. And even if there is complete diversity, then it has to be over $75,000. So anyway, I hope that this is helpful and you found this interesting. And if you have any questions or comments, just feel free to put those below, and I will catch you guys in the next video. Thanks. Bye.